Let's go.
Well, hello, everyone. It is Monday, October 13th. Kostas, how you doing today?
I'm good, man. Thanks for having me on.
Hey, thanks for being here, brother. This is the first ever edition of Behind Enemy Lines. It is 5:01 p.m., and I would like everyone to know right now that the Seattle Mariners lead the Toronto Blue Jays by a score of 10-3 in the top of the eighth inning. That would put them up 2-0 in the American League Championship Series. So, Kostas, I'm in a good mood right now, at least. How are you doing?
I'm good too, and if the stream abruptly cuts out, that's how you guys know that the Jays are making a comeback. So
yeah, exactly. If you start seeing me throw crap around the studio here, it becomes the Kostas Moros show because I gotta go, dude. All right. Hey, listen. Just want to let everyone know. First of all, thanks for joining us. What we're gonna do is we got a bunch of segments to get through tonight. We're gonna talk about a bunch of different things. We are also going to be joined by a special guest later on. We got Miss Hannah Hill from the National Association for Gun Rights joining us. We got all sorts of things to talk to her about. And then we're going to wrap it up ourselves. But want everyone to know that our next Behind Enemy Lines will be Monday, November 10th. Same time, same bat channel. And Mark Smith from Four Boxes Diners has agreed to join us for that one. So we're going to have a super geek out session with Mark Smith. Kostas, you ready to do this?
Yeah, maybe by next month I'll have a HD camera instead of whatever.
You look great, man. All right. All right. Listen, hey, first thing we're going to talk about this kind of, I think came out of nowhere because it didn't come out on a normal Monday orders list. I think it came out on like a miscellaneous orders list, like midweek, which is kind of a hodgepodge of stuff. But Wolford v. Lopez gets accepted by the United States Supreme Court. First of all, your initial thoughts when you heard that?
Well, I think it's appropriate it came out on a miscellaneous list because the Supreme Court forgot the Second Amendment existed. And it was like, oh, yeah, that's right. We can grant cert on these cases. Yeah. So they granted it. And I think, look, the vampire rule is a very important issue because more than anything else, it kills the right to carry beyond any other particular sensitive place restriction. But
why don't you do this real quick for the viewers who may not be aware of the vampire rule or live in a state where they're allowed to live free like Americans? Why don't you describe what the vampire rule is?
Sure. So we've nicknamed it Rob Romano, and I've stolen it, nicknamed it the vampire rule, because what it does is that if you have a permit to carry, or I should say, even if you have a permit to carry, you can't carry in a private business open to the public unless they post a sign or otherwise give you permission to carry. So it's like vampires from Dracula. If you saw the movie Sinners earlier this year, vampires can't enter a building unless they're invited in by the owner. So they treat us basically like we're vampires.
Okay. All right. And the interesting thing is that I believe that this was this initially overturned at the lower court level and then reversed by the Ninth Circuit, or was it upheld at both by the Ninth and at the lower court?
No, it was, I think it was an Obama judge, Judge Kobayashi, who struck it down and agreed with our judge in our case, Maybe Bonta, and then the two cases were heard together, 3 actually FPCs as well. So 2 California cases and a Hawaii case. And then the Ninth Circuit reached this bizarre ruling where they struck down California's version of the vampire rule because it only provided for a sign. And the Ninth Circuit said that's not okay. But because Hawaii also lets you get permission, not just seeing a sign, that was fine. It was this really nonsensical distinction. And the Ninth Circuit became the only court in the country, this is including the Third and Second Circuits, that has upheld the vampire rule. So even a very gun hostile Second Circuit struck down New York's version.
That's right. And that was one of the things I wanted to ask you, because a very similar rule was passed in New York. I think it's part of their Concealed Carry Improvement Act, or their Bruin Response Bill. And the Second Circuit, not the most pro 2A circuit in America either, they struck it down, correct?
Yeah, and I think they saw the writing on the wall. Like, this would be the thing that might get the Supreme Court to grant cert on a preliminary injunction. And sure enough, I think the Ninth Circuit, that Ninth Circuit panel probably wishes that they granted our en banc petition right now. I think they regret this move big time.
Well, so what I want you to explain though to the viewers is because they're like, oh, that really makes things inconvenient, but it goes beyond a massive level of inconvenience because it really does completely eviscerate the right to keep and bear an arm outside of the home. So explain that to folks so they can understand just how severe this law really is.
Oh, I mean, if you think about it, and this is why when they asked Governor Hochul when it came to New York's version, well, where will people still be allowed to carry? And she said, I guess some streets and sidewalks, very dismissively, like, because they know that especially with this particular restriction on private businesses, that's where most people go. You're going to the grocery store, you're going to some restaurant, any place of business that you're going to go to is going to be affected by this. So you can avoid parks and bars and the other places they restrict. You're not going to be able to avoid all these businesses that are held open to the public, right? And very few of them, even if they're fine with people carrying, are ever going to put up a sign or otherwise give permission because they don't, especially in anti-gun states, they don't want to spook their other customers. The other customers are going to see that and be, what, guns are allowed in here? You know how people are. So
exactly. And then of course, when you walk up to that ABC Mini Mart in Hawaii, not that there's any of those around there, but let's say you happen to find one. What do you have to do? Actually go to the store owner. It's like, hey, by the way, do you mind if I walk in here with a firearm?
I'm armed. Can I come in? Like, how does that work? Like you're going to get the police called on you or something.
Right. Okay. Now, California, though, had something, a Senate bill, I believe it was Senate Bill 2 down there, which created all sorts of new sensitive places. We call them gun-free zones here in Washington. What do you call them in California?
Also gun-free zones, but the legal term is sensitive places now. But of course, we dispute that they are sensitive.
Right. Do you have any similar thing involving private property held open to the public?
Yeah. So that's what I was saying earlier, how our version, the Ninth Circuit, struck down California's version because California's version required a sign, but Hawaii's version required either a sign or any form of permission. So if the owner waved you in, that'd be fine.
Then based upon some of the legislation that we've seen passed in California, signed by the governor just last week, which we'll talk about a little bit later, I'm assuming they'll just go back and redraft this a bill and write it consistent with that.
We suspect that, but curiously they didn't. So last week they signed another bill called AB 1078, which made several changes, and they did change the public transportation rule. So the Ninth Circuit struck down public transport, but they said, but if California said you could lock up the gun and put it in on the public transport, then that's fine. And they did exactly that. They changed it. So now you have to lock up your guns on public transport, but they didn't change the vampire rule. And I think they saw what we saw, which is that this is just Supreme Court bait. And that ended up being the truth, So, and I wouldn't be surprised, by the way, if Hawaii repeals the law now to try and moot out.
Try to moot it out?
Yeah. I think that's a 50-50 shot right now. It would not surprise me.
How do you think the Supreme Court would react to that?
I mean, they hinted that they were upset a few years ago, the year or two before Bruin, when New York did exactly that. If it happens again, either change the mootness precedent, set some rule that after cert you can't moot things anymore, we're going to decide it. Or alternatively, the better solution, I think, would be to grant cert on 5 other Second Amendment petitions.
I just don't know how you're going to write that into a Supreme Court rule.
You don't have to write it into decision. They could just say, okay, the case is moot. By the way, we're granting cert on Duncan, on all these other cases.
Miller. We're inviting everyone from Illinois to hop aboard. Come on over. We're going to decide the 18, 19, and 20-year-old issue definitively once and for all. This case is in an interlocutory phase. Let's talk about that because, there's this urban legend that, the Supreme Court never accepts anything in an interlocutory phase. For you non-lawyers, it means it's before the football game's over. Okay, we're somewhere in the second or third quarter, and we're trying to appeal a decision that the referee has made already. What say you about that? And do you think there was anything unique here that would make this an outlier in some ways?
Yeah, the federal government did an amicus brief. That's why this got cert. I think even otherwise, I think what would have happened is we would have gotten another very concerned concurrence from Justice Kavanaugh denying cert, being like, "But we're watching you."
One of these days, we're probably going to come around and do this.
But in this case, there was an amicus brief from the federal government, which is the first ever pro-gun amicus brief. Since then, they filed others in the circuit court. And I think that made all the difference here. I think that's why this got cert. I also think, unfortunately, it's why they limited the question to question 1 and didn't take the question on time period because the federal government asked for exactly that. They said, focus on the vampire role, don't worry about the time period. So that's what we got. But beggars can't be choosers.
So in our first ever experiment of what happens when the U.S. Department of Justice files an amicus brief before the United States Supreme Court, it is that we got a little echo going on here.
No, I think my screen just went black though. That's weird.
Okay, well, you're still looking good. Hey, there you go. All right, here we go. So, anyways, now that I got myself echoing over here, give me a second. Do you think that this shows us that now with DOJ coming in and saying we want the court to do exactly this, that we could see this kind of persuasive effect in the future with this DOJ filing other amicus briefs?
I think so. However, and I'd love every major Second Amendment question get an amicus brief, but I would say they should probably focus on a handful of important cases, because if they do it too often, it's going to lose its value. If, you know, for example, the state attorney generals file briefs in all the big cases, and we love them for it, and that's very helpful. But I think it's gotten to the point now where the Supreme Court just kind of expects there's going to be the 25 or 30 or so red state attorney.
Yeah, 26 authored by Andrew Bailey or the guy out of West Virginia or Austin Knudsen out of Montana. One of those three.
And it still helps, but I think to make it stay an important thing when the federal government does a brief, they should probably be selective, on what they're filing in.
Are you aware of the federal government having any other amicus briefs at the Supreme Court level right now?
Outside, I hate the law other than the Second Amendment, so I don't pay attention. No, just kidding.
Sure. I meant in Second Amendment cases. If I ever ask another terrible question like that, just understand that it will be only within the confines of the 2A. Most people aren't tuning in to check about their searches, their right to be free from unreasonable searches and seizures here, but
no, we were hoping to see one in Duncan. They didn't end up filing one in Duncan because I think partially because of what I just said, they want it to be meaningful when they file it, and partially because I think they're putting their chips in the circuit split basket. That's why they filed in the Third Circuit and in the Seventh Circuit these amicus briefs, because I think they're hoping to create a circuit split.
Well,
unfortunately for us, I think that they think Justice Kavanaugh meant they're not going to take Duncan right away. I hope they're wrong, but we'll see.
Well, that's funny. It wasn't on the list of things to talk about, but I do want to bring this up, which is that the United States Department of Justice did file an amicus brief in Cheeseman v. Platkin, which is a challenge to New Jersey's assault weapon ban. And the state of New Jersey Attorney General decided to file a response brief to DOJ's amicus brief. Have you had a chance to take a look at that?
Yeah, I did look at it. It was not anything surprising other than the very angry tone.
The very angry tone. They got really pissy about that one.
It was amusing to read that.
Listen, you've been doing appellate work for a long time. How many times have you ever seen somebody actually reply to an amicus brief at all, let alone in that fashion?
It doesn't happen often, and usually it's when you're doing a brief anyway, you might address some points from an amicus, but I think in this case, it's the federal government. So I don't blame them for responding. I think it merits a response, but their response was, the same old arguments, right. What if machine guns were legal?
Well, that was the thing. They weaved that whole thing that even though they were at one point in the memorandum, they were like, I know the government says it doesn't legalize machine guns, but we don't believe them. That was literally one of the arguments they were making there. They're up to no good here.
I think that's they need the court to focus on that, because they like all these cases, they want to tie AR-15s and other common semi-auto rifles directly to machine guns. That's their only hope to scare the judges.
All right. Prediction? What's the odds right now on Hawaii trying to moot Wolford out?
I'd say 50-50. I don't have any special knowledge, but if I were Hawaii in their position, I'd moot it. It would just be very funny, though, because this whole time they've been arguing in court what a critical public safety measure this is. So if they just scrap it to avoid Supreme Court review, there might be a silver lining if they do that, because I do want Wolford decided. But if it angers the judges a bit and gets them to look at more Second Amendment cases, that's not the worst outcome.
Well, because I think one of the themes with Wolford coming out, and I think this is something that you actually wrote extensively about, is all the gamesmanship that's going on in the Ninth Circuit.
Yeah, and that's why I'm glad they're finally taking a Ninth Circuit case in particular, because this circuit does need, to be reprimanded. We know the Supreme Court knows about it because Justice Gorsuch mentioned it in his Rahimi concurrence about the Ninth Circuit's 50-0 record against the Second Amendment. Now it's only gotten worse. I guess it's like 60-1 now because of Nguyen. But other than that, it's still a very terrible record. So we're hoping that the Supreme Court, if they do end up deciding Wolford and it's not mooted, that they say some very choice things to the Ninth Circuit about their behavior.
Well, any other final thoughts you got on the Wolford case or anything like that before we move on to our next topic?
Just that if they do decide it, I hope they don't keep it as narrow as possible and literally just say vampires were bad. We need some more guidance for these bad circuit courts when it comes to the other sensitive places as well. So
well, and you bring up a good point there, because when it comes to the sensitive place, because here's the thing, gun laws are going to ban people, places, or things, right? So that's all they do. They ban either people, places, or things. When it comes to places, they get incredibly creative with the history there. I mean, they get creative with all the history, all the places, but at least when it comes to things, platforms and stuff, we've kind of already done the historical analysis already.
Yeah.
Right. That's been done for us. But you get into these places and you take a look, for example, out of Schoenthal, the case that came out of the Seventh Circuit on Illinois' public transportation ban. People gather. It's a large metal tube. It could be gathered, right? You're seeing these other rules of law. It could be potential to be crowded, potential to be visited by children, and that all of a sudden equates to sensitive places. But when you go back and you look at the history of sensitive places, it's far narrower than that.
And public transport isn't even the most nefarious one, because at least they can kind of say that's sort of new. Trains existed in the 19th century, but places like bars and libraries and stuff, those all exist. Those have existed for centuries, and yet they're still pretending they're some new place that is crowded. Okay, everywhere can be crowded.
I think the only restriction on firearms in libraries should be that they all have to be equipped with a suppressor. That's the only restriction we should have on firearms. And all right, hey, here we go. This is interesting. This is really interesting. We heard that they were actually commencing an investigation, but they've been investigating a lot of things, and DOJ's promised a lot of things. Suddenly, we end up with a suit. The United States Department of Justice sues Los Angeles, United States versus Los Angeles County, and the Los Angeles County Sheriff Robert Luna. Did you see this one coming?
Yeah, I asked them to do this.
Well, thanks for asking. Thanks for asking, man. What county do you live in again?
Yeah, I mean, during the transition period before Trump took office, after he had won the election, I suggested this. I said they should investigate LA and sue them. And soon after, they started the investigation and they sued them. And I think part of it is a good idea, and part of it is it's a low controversy move because I think a lot of people who are skeptical about the Second Amendment, if they're fair-minded, would agree that 2-year wait times to exercise a right are ridiculous, right? So
let's take a look at some of the numbers that were cited by the United States Department of Justice in their complaint between January. This is Los Angeles County, which I'm assuming this is not exclusive to LA County. I'm assuming there are other counties that are as, if not more, culpable. I know there's a lot of counties out there that really do let their citizens live free like Americans, but what are some of the other more egregious counties that we should be aware of here?
Well, the city of LA, LAPD, right down the street is just as bad. Alameda County takes a long time. And then there's others that aren't as bad, like taking 2 years, but they do take over 6 months.
There's some that actually just have exorbitant fees too, is there not?
Yes, yeah. We've sued Santa Clara over that. They charge about $2,000 in total expense for a CCW permit. So.
Oh my God. All right, so listen to these numbers. Between January of 2024 and March of 2025, there were 3,982 applications submitted to the Los Angeles County Sheriff's Department. During that same time, they approved 2.
Yeah. And that's a little bit, I think people are misunderstanding that. It's not that during that whole year-long period, they only issued 2 permits. It's that they were processing applications from before 2024, because you have a 2-year wait time. So, of course,
right. So of that 3,982 applications that came in during that window of time,
yes, of those only 2 got
there may have been 42 granted, but the other 40 actually predated January of 2024.
Exactly. Yeah.
All right. The average wait time supposedly in Los Angeles County, for them just to start processing the application is 281 days. Is that about right?
Yep. In fact, that's faster than it used to be.
Oh, God. All right. And the median wait time, the median wait time to get your license is 372 days, a little more than a year.
And that's, again, also faster than it used to be.
Yeah. Okay. All right. Now, how many people who are applying for concealed carry licenses have to be subjected to an in-person interview?
Everybody.
Okay.
For the first timers. Yeah.
The first time. So on a renewal, you don't have to, but the first timers, they all have to sit down and
other than non-residents who can do it virtually, but no non-resident should be applying in LA. You're making a big mistake if you apply to LA.
Right. Yeah, exactly.
You get the choice. We don't. So don't apply with that.
Right. Okay. So you've done one of these interviews. Tell us what these interviews are all about.
They basically, the interview isn't that bad unless you have a sorted record, I guess. But if you have a clean, boring record, they'll basically run through the same stuff the application asks you and try and see if you're lying. Like, have you gotten any tickets recently? Have you ever committed a crime? Are you married? Have you ever been divorced? Have you ever abused anyone? It's that sort of thing. And I think the point of the in-person interview isn't that they think they're going to find something they can't find. It's just to add another thing to make it hard. Like most of the steps they require, it's the state putting barriers in front of you to hope you just give up and don't bother, So.
And I'm assuming that each department only has a very limited number of people who conduct these interviews. So if you got a few thousand applicants in a large populated county like, Los Angeles, they're all having to be funneled through 2 or 3 people?
Yeah, I'm not sure of the exact number. I know the CCW unit now in total is 12 people, but I don't know if all 12 do interviews. They have different staff doing different stuff. And I bet they only have 12 because we sued them a couple years back and now they're getting sued again. It was probably much less before. So
okay. All right. Well, we're going to, and one of the things we're going to do at the end of this today is we're going to actually end up checking in on your renewal application, because I know that you've been through this process for a while. So, all right. The suit is filed in the United States District Court for the Central District of California, I believe.
Yes.
Where's that located?
It mostly covers LA and the surrounding area. It's and they related it to our case, CRPA versus LASD, but actually that didn't take. And they actually got assigned Judge Scarsi, which is probably better because he's a Trump-appointed judge. So we'll see how it goes.
Okay, so right now you're feeling. Do you think there's a possibility that LA tries to step in and settle this suit?
Oh, definitely. I mean, I all it takes really is for the county to say, okay, you know what? We're going to give you a pile of money. Here's a bunch of staff. Rip through these applications really fast and clear the backlog. I think eventually they're just going to do that because they don't want the precedent. I could be wrong. It could go the other way and they could see it like, no, we have to stand up to Trump, and then they'll resist the whole time. And that'd actually be better for us in terms of getting good precedent if they want to take it.
Well, let me ask you this. One of the things that people get a little caught up on, especially those in the civilian disarmament, is Bruin footnote 9.
Mm-hmm.
Right. This whole, as long as you're just using objective criteria and you're not using them to abusive ends, then that's per se constitutional. Now, you and I can do a whole separate show about how that was meant to be a shield and instead is now being used as a sword by those on the other side. But this is an example, because I'm assuming that LA is going to claim that these are all objective criteria, even the interviews going through objective criteria, just trying to figure out if there's a disqualifying offense, right?
Yeah, they're going to say that, and they have said that in our own litigation on this issue in CRPA versus LASD. And they'll blame the state. They'll say the state requires this. But look, while we have a lot of issues with what the state requires, other counties do this within the 120-day time limit. Riverside takes a couple of months right now to process it. So there's no excuse. They can get this done. They can jump through these hoops in a timely manner. And by the way, if their complaint is with the state requirements, they can go talk to their friends in Sacramento. You can change that law. It's not our problem.
Is there a statutory requirement currently in California law?
Yeah, it's not being enforced, though. So California law has a 120-day time limit for processing permits, but unlike other states, there's no provision that says, oh, if you pass that, then you get to carry on your application until they decide it. So we've before we filed our lawsuit of CRPA versus LASD back when I was back with Michelle and Associates, we sent the Attorney General a letter and we told him about this issue. And we told him, hey, you should enforce this penal code. No response. And in discovery responses, they basically said, well, that's on the sheriffs to enforce that provision. It's like the sheriffs who are violating it are going to enforce it against themselves. It was a nonsensical position for the Attorney General to take, but that's where we are.
Okay. So if you're going to look into your crystal ball, where do you think this suit's going to be 3 months from now?
I don't know if it'll move that fast. I hope we have some good settlement progress in 3 months and LA responds rationally and moves to fix this issue. But if they're going to be stubborn about it, it's probably going to take a bit longer than that. There'll be some more discovery and maybe we'll get some sort of motion for summary judgment, hopefully sooner rather than later. But I've never really tracked a federal DOJ lawsuit. I don't know how if it's directly comparable to the sort of litigation I've done. Maybe it is. But, yeah.
Okay. All right. Well, listen, this is where we're supposed to have Hannah Hill jump in, but she hasn't jumped into the studio yet. So I got to come up with a time killer, but I'm going to come up with a good time killer. I want to circle back on something you talked about earlier, which is United States Department of Justice filing amicus briefs, but doing so on select cases so they don't essentially become the boy that cried wolf, right? Mm-hmm. And obviously we want them to be on what you and I would both consider to be like the big issues, which is, hey, look at that.
Oh, there we go.
Look who's here. Wow. I was actually going to add her. I didn't expect to add her in. So she's here now. Now we're going to have to deal with her.
I thought it was going to be a waiting room. Sorry about that.
No, I just dropped you on the stage right away. I was actually coming up with a time killer while we're waiting for Hannah Hill to get here. But hey, you good, Kostas? I'll circle back with you on that one.
Yeah, no problem.
Hey, everyone. Look who we have here. We have Hannah Hill from the National Association for Gun Rights. Hello, Hannah. How are you?
Good. How you gentlemen doing?
We're doing great. Thanks for joining us.
Absolutely.
You're our first official guest here on Behind Enemy Lines.
I am honored. I've actually been looking forward to this show even before y'all invited me to come on. So I was pretty tickled to be invited.
You're not so much behind enemy lines anymore, are you?
I am not. I fled to the state of South Carolina, where I'm originally from. So we are no longer under the anti-gun regime of Colorado. So very happy.
I understand you left a few refugees behind in Colorado that will eventually migrate towards South Carolina at some point.
We're hoping. We're like, you can live in freedom. It's way better on the other side.
Well, why don't you tell everyone real quick, in case they don't know who Hannah Hill is and what Hannah Hill does, why don't you tell everyone real quick about yourself?
Well, I'm the Vice President of Litigation at the National Association for Gun Rights. My background is in state-level public policy. I worked for a think tank back in South Carolina. Basically, we were a watchdog think tank, blowing the whistle on state legislature. We would look at what the state was actually proposing to do, what the lawmakers were proposing to do, and then blowing the whistle to their constituents. So we were not very popular at the State House, and that meant we were doing our job. So and then the National Association for Gun Rights came knocking. They said, we want to build a legal wing. That the lobbying operation was on point, thanks to the work that they were doing, both on the lobbying side and elections side. We've to date passed constitutional carry in over half the country, but there was a lot of work and a lot of room for another group to really start a litigation arm, because there's more gun control, as y'all know, I was listening to the show before I jumped on. There's more gun control out there than you can shake a stick at. And
no, really?
There's plenty to go around. So we thought that there was room for us to get involved in that as well. So I came on 5 years ago. I moved to Colorado in 2020 between the two shutdown waves, which is an interesting time to move to a deep blue state. So, and we've kind of learned as we went. We've built up a litigation wing, and yeah, that's what brought us here today.
All right. Well, we got a bunch of things to talk about, but first of all, I want to make the record clear. You come from a deep blue state like Colorado, but I will point out that I'm from the state of Washington, and nobody comes from a bluer state than my colleague, Mr. Moros here, okay? Because they are the king of crazies. All right. And we're going to talk to you about a few things, all kind of related to some stuff going on with National Association for Gun Rights, one of which is the case of National Association for Gun Rights versus Lamont. It is a challenge to Connecticut's assault weapon ban, had a preliminary injunction denied, started ricocheting up into the Court of Appeals. And after a brutal ruling, which we will go over here in a moment, the NAGR has decided in an interlocutory phase to appeal that matter to the United States Supreme Court. So why don't you tell us a little bit about the thought process that went into that decision?
So the Supreme Court on this case took us for a wild ride, so we thought we'd return the favor, is kind of what it comes down to.
All right.
So when we filed this case, right, it was immediately after Bruin, right? So Bruin was handed down right about the same time we were filing a couple of gun ban cases in Colorado. And we scored 2 back-to-back temporary restraining orders against those gun bans in Colorado. And that's kind of what, at that point, we're like, okay, we've got something here, right? Now, in hindsight, and with the benefit of hindsight, what we know, obviously, is that they just hadn't had a chance to put their heads together and figure out what workarounds they were going to use, which meant they had no choice. These Obama and Biden appointees, they had no choice but to rule based on the ruling, based on Bruin, that is. So basically, we started filing. We don't want to duplicate lawsuits unnecessarily, so we were looking, okay, what are some unchallenged gun bans? One of those was in Connecticut. So we filed a lawsuit challenging Connecticut's assault weapons ban and magazine ban. We asked for a preliminary injunction. This was before the Supreme Court started denying all interlocutory appeals on the Second Amendment. So we thought, and at the time, that was good strategy. And the Second Circuit, so the district court obviously ruled against us. That was expected. Went to the Second Circuit, and they really dragged their feet, right? Took forever to get there, took forever to get oral arguments, took forever to get the ruling. In the meantime, the Supreme Court starts saying, you know what, we're not really interested in interlocutory appeals. And we start getting statements from them to that effect as they're rejecting them all. But before we can take Lamont back down to the district court and go through the merits, go through the full lower court process,
which would be a complete exercise in futility. We got to acknowledge that, right? I mean,
it would.
Kostas, I think you guys are in on that case as well.
Which one?
Lamont.
I think we have a partner case. Yeah, I'm still learning about thousands of cases that we have.
All right. Well, next month we'll hold you accountable for all of them. Right now, you're only accountable for the first 500. Okay.
Yeah. And the interesting thing about that is that both ours and SAF's case were, both on an interlocutory basis at the Second Circuit, right? So neither one, we're both tied up there. Can't go through the merits till the Second Circuit rules, which they finally did. Oral arguments there were kind of brutal. It was like going before the legal version of The View. And then they gave us a ruling that was probably the most defiant ruling we have seen yet. Where they, we're used to seeing them defy Bruin. We're not used to seeing them just say, you know what? Yeah, Heller didn't mean all weapons in common use for lawful purposes are protected.
Well, yeah. Let me jump in there for a second because I pulled a couple of quotes from your petition here. I got them right here, but I did a video on it, and I thought it was a really well drafted petition. I told you that. According to the circuit court, even if the banned weapons are in common use, it may nevertheless uphold the state's ban because Heller did not really mean what it seemed to unambiguously say, that the Second Amendment protects weapons in common use by law-abiding Americans. Instead, according to the circuit court, this court's precedents do not shield popular weapons from review of their potentially unusually dangerous character. They did kind of thumb their nose at the common use test and some of the other rules of law, didn't they?
They did. I mean, look, in terms of defiance, it doesn't get worse than that. But so that's one reason, and we decided to go ahead and take it to the Supreme Court. Look, guys, what better argument do you need for the fact that you need to step in and smack down some of these old rules? But there was also another reason. And that is the fact that if we went through the district court process and we built a record, literally the only fact we have to establish is that the banned weapons and the banned magazines are in common use for lawful purposes. Well, the Second Circuit already conceded that. We have no facts left to establish in a record. So it would literally do no good to actually go through that process. We have everything we need to take it to the Supreme Court now. And then the third reason was really, we're starting to see the Supreme Court that they are willing to step in on an interlocutory basis. When
Well,
they
yeah,
have
we
to.
already talked about the Wolford case, which we
Right.
now know has been taken.
So, no one really knows what's going through the minds of the Supreme Court. All we can do is make the best place we can and not keep knocking at the door of the Supreme Court till they let us in. And that was the thought process. That's why we took that one up.
Kostas, I got a question for you about this too. And this is actually going to go to what was my time killing question that I didn't have to kill time. But you had talked about how United States Department of Justice, if they're very selective in their amicus briefs, and we were talking about big issues, and obviously an assault weapon ban is about as big as issue as we got right now in our sphere. Now you have Lamont sitting up there, but you also have the Viramontes case sitting up there out of Cook County as well. Could you envision DOJ jumping in on one of those, or you think they're going to wait and do like a Miller v. Bonta or one of those other cases out of Illinois that's got a really, really well-developed record?
Unfortunately for both us, because Viramontes is an SAF case, and for Niagara, I don't see them doing an amicus brief on either case. I think they have all their eggs in the Third Circuit and Seventh Circuit basket. I think that they see it as, based on their actions so far, they see it as the Supreme Court's going to take this issue up more likely sooner if there's a circuit split. And so that's what they're trying to generate, especially in the Third Circuit. We have that en banc argument on Wednesday.
Day after tomorrow.
Yeah, so we'll see how that goes. But I hope I'm wrong. Hell, I hope they do file an amicus brief. And I actually agree that we should keep, even on preliminary injunctions, filing cert, just to remind the Supreme Court, like, hey, we still care about this. Like, you got to deal with this. And even if they don't take it, you just got to keep, as Hannah said, banging on that door, and hopefully they open it eventually.
Well, it's kind of what's the worst they can say to you? No, we're not taking it. Right? Yeah. You miss 100% of the shots you don't take.
Yeah.
Well, and in addition, when they turned down Snope was the perfect vehicle. It had gone through the merits. This was the second time it had gone to the Supreme Court. It was, GVR'd after Bruin. And it was extremely defiant, a very outrageous ruling, one of the more outrageous rulings to date. And it was everything they had said that they wanted, and yet they said no.
And I think that's why Justice Kavanaugh wrote that statement. Like, I think he knows how not great it was that the Supreme Court did that. So that's why he's like, well, we promise we'll do this soon, guys. We promise.
How not great. That is a really nice way of saying what a bunch of bullshit it was. So
that's right.
Yeah. Speaking of outrageous, this is not outrageous. Magpul is not. But can you imagine, Hannah Hill, if you actually had to establish that magazines that hold more than 10 rounds or semi-automatic rifles that accept a detachable magazine are actually in common use? You would actually have to put on evidence to that effect. Have you ever come across a case where that had to happen?
Oh, you're triggering my PTSD, Bill.
Yeah. Has there ever been a case where a court jammed me up on that?
So much so we actually had to withdraw one of our cases because they threw out our expert witness, who was going to testify to that. Again, that's one of the many tricks that leftist judges have up their sleeves, and they'll take as we all know, they'll take every chance they can get to throw roadblocks in our way and to kill our cases.
Well, you got this case out in Massachusetts where you're getting jammed up on exactly that. So what is it that NAGR is trying to do? Because it's coming. You know that they're going to jam you up that way.
We do. We know it's coming. Right.
Yeah.
And in this case, unlike in the Second Circuit, the First Circuit, when they denied our motion for preliminary injunction, they didn't concede the common use question. So we still have to establish it in the record. So basically, we are very, very happy to be working with Magpul.
Oh, okay. All right.
Thrilled to be able to have Magpul's assistance. Now, there's a protective order. We respect that. Magpul, they have their business interests to look after. So I'm very happy to work with them on that. But they're also very happy to work with us when it comes to establishing common use, which which Heller seems to establish as a numerical question, right? Common use is basically what have the American people chosen as their weapon of choice. So, and that's not a judicial determination, and that is, as we see it, it's a straightforward numbers inquiry. So, thrilled to have Magpul's partnership in that.
Kostas, have you ever had to do in working on all the pieces of litigation you've had to work on? Have you ever had to literally go out and try to drum up numbers to prove that an item is in common use?
No, because at our trial court in Duncan, we had St. Benitez, so we didn't need it.
He just was going to accept it as it's kind of like accepting the fact that the sun sets in the west, though. I mean,
Yeah,
it's a pretty obvious,
It's so frustrating when judges do this because everyone knows these things are common. In fact, that's one of the complaints from the states that ban them is how common these deadly magazines are, and all of a sudden
interesting.
they're going to play stupid. But it won't matter, of course, because if the judge doesn't like you, you'll get all this great data, which is going to be helpful around the country to have that information, by the way. But the judge will just say, well, maybe they're common, but they're still unusually dangerous, which is now what we're calling dangerous.
Right.
Or they'll say it's not. It may be commonly owned, but it's not commonly fired for self-defense. No, is it? And then they'll start going to average numbers of rounds. Fired.
Yeah, but that gets into the whole. If I have to display a firearm that holds a 17-round magazine, and my perpetrator takes off, says, I picked on the wrong dude. Guess what? I still use the 17-round magazine in self-defense. I just didn't have to discharge any of the rounds.
Right. Well, and when it comes to us, we have to bring the facts to prove the arguments that we're making. And so we'll we'll lose at district. We know that. We'll take it to appeal. And the goal here is to bring the Supreme Court a record that they can't argue with.
Well, and I appreciate NAGR taking this one because, I read the petition. I got a sneak peek at the petition before you guys actually filed it. I appreciate that. And this was an outrageous ruling. This was a real double middle finger to the Supreme Court and some of their precedent. And I think that when you do take a look at some of the outrageous rulings that we've seen, Kostas, you know this more than I do, Evan, this one really does actually stick out amongst the crowd of really bad rulings.
Yeah, I mean, at this point, I'm numb to these rulings. Like, I just read them like, oh yeah, Bowie knives, sure, unusually dangerous. Like, I used to get angry. Now I'm just waiting for this because I don't even blame them at this point. Like, if the Supreme Court's not gonna, come in and discipline them, then why wouldn't they just keep topping themselves with ridiculousness?
Right.
So it's ultimately the Supreme Court's job.
They're like kids. You got a couple little ones. You know this, Kostas.
I got one.
You got one. All right. Listen, if you don't discipline them, they're gonna run wild on you. Okay. You got to put up boundaries. Okay?
I let my wife do the disciplining. I'm the sucker.
All right. Well, Hannah, we got one more thing to talk about. You know what that is?
You want to swear me in before you put me on the stand,
it's the straw that broke the camel's back. Oh my God, the back of the camel has been broken apparently. Listen, on October 10th, Dudley Brown, who's president of NAGR, hell of a nice guy, know him well, love him to death. But you guys came out very publicly and very adamantly that Attorney General Pam Bondi should either step aside or be terminated. And one of the big reasons, and actually the straw that broke the camel's back, according to that statement, was a thing that was going around about the Reese versus ATF case. Okay. And where it had appeared that the United States Department of Justice had asked for and received an order from the court that certain membership data would have to be turned over to the Department of Justice in order for them to determine who was in the named plaintiff class that would get relief from this. Okay. And it had all of us a little worked up. I did a video on it. But in that time, since the time that NAGR made that statement, we now have an additional filing in court, a joint motion of the parties, where that has significantly changed in complexion. So my first question to you is this. Does NAGR still stand by its proposition that Attorney General Bondi should be terminated and or resign effective immediately?
So what we're saying now is that, look, if she has made it very clear since we put that out that, Harmeet Dillon responded, it is very important to this Department of Justice that Pam Bondi be seen as a Second Amendment advocate. All right. So what we're saying now is prove it. We would love to be proven wrong. We would love to be proven wrong. But what we're going to have to see is more than what we've seen over the last 8 or 9 months. Right. So there's a list. We just actually put it out, a list of things that she can do to basically begin the process of rebuilding faith with gun owners. A lot of this has been building up. The dissatisfaction has been building up for a good long time. We've been getting promises from them. We've been getting promises of review. And then we've been getting this bipolar strategy from the Department of Justice where they, on the one hand, do amazing things, like filing lawsuits in California against LA County in defense of the Second Amendment on one hand, amicus briefs, participating in oral arguments, all against state and local gun control. But on the federal gun control side, it's been much more of a mixed or even a negative record, culminating in this case where basically they told the judge that the plaintiffs have to choose between their First Amendment rights and their Second Amendment rights. And the concern is not so much that they rolled it back, but that was the bare minimum. They have to roll it back. They got to fix it. They really, really stepped in it. The problem is that there are people at the DOJ driving cases and making decisions that thought that was okay to say in the first place. So, if Pam Bondi wants to be seen as the Second Amendment advocate that she claims to be, she needs to prove it.
Okay. So you came up with a list of things.
We did.
Like what?
So first off, we need to see the engaged in the business rule, which cracked down on private firearm sales, the rule that basically killed Brian Malinowski. We need to see that repealed. No more promises of reviews, no more revisions, no more anything like that, right? They know what the text is. It should never have been enacted by the Biden administration. They need to begin the administrative procedures process of rolling that.
Okay.
That's probably the top priority if you ask anybody on our staff. Second priority is going to be to stop making the anti-gun legal arguments in court, right? So on the one hand, with some cases, they're saying the right thing. On the other hand, with some cases, they're saying the wrong thing.
Such as?
So on this very issue, gun rights for 18 to 20-year-olds, right? So you have this one here. And this one's in the Fifth Circuit. We won that one. By we, I mean the gun owning community. We won that one. But then you have a handful of other cases also challenging this issue at the Supreme Court. And the Department of Justice is not asking the Supreme Court to step in and reinstitute rights for military-age American citizens.
Okay.
They're not.
Are you referring to the McCoy case?
I am. That's one of them. That's one of a handful. Another one is NRA versus Glass, which used to be NRA versus Bondi, right? That one's a challenge to Florida's law.
Kostas, you familiar with these cases?
Yeah.
You got any questions right now?
SAF has several 18 to 20 cases proceeding. I don't remember all of them off the top of my head.
Right.
Okay, we won't hold you accountable for that as well. Now, I thought, Hannah, on the McCoy case, there were two issues presented. One was, the constitutionality of 18 USC 922B1, I believe it is. And then the other one had this boring crap about was the class action, the class properly certified. Yes. I mean, God, I don't no interest in that. What they asked the Supreme Court to do there was reject the petition on the class certification and hold the petition on the constitutionality because the NRA versus Glass case, and I think is it the New Jersey case also that has similar constitutional challenges to B1 coming up?
So there is another case, and I forget the name of that one.
Kostas, do you know what we're talking about here?
I do, but the name isn't coming to me.
Okay, so we don't have to use the name of the case because probably 99% of our viewers are like, I don't care what the name of the case is, but we can talk about it anyways. Right.
Well, I mean, the point is though. So yes, they relied on technicalities. But again, I was listening in on the show and the discussion y'all had before I jumped on. We know that when the DOJ asks for something, the Supreme Court listens. If the DOJ was interested, okay, so they have in the Fifth Circuit, they say we can't give a universal injunction to restore rights to all Americans. Okay. Well, if that was a problem and they actually were advocating for the Second Amendment, they have vehicles over on the Supreme Court side that they could ask to have resolved, right?
Explain to me procedurally how you believe that would go down.
Okay, so now since I'm not an attorney, Bill, I feel like you're setting me up.
That's why I'm asking you.
Right. So there are multiple. So in the first place, like I said, there are multiple ones. The appellate court actually overturned, the class certification was the issue with the 18 to 20-year-olds, right? Because the plaintiffs had aged out of the process, and then they added on and they asked to have it certified. All right. do you overturn that? Because I believe the class certification came after final judgment at the district court, and that was the point of contention at the appellate level, if I'm recalling the facts of that one correctly.
Right, but if the heart of the matter is the constitutionality of
Mhm.
922B1,
Right.
and
why
right
did-
now you have a circuit that has struck it down for named plaintiffs in these organizations and the actual named plaintiffs. Would it not actually require, and Kostas, you jump in here on this too, wouldn't it almost require the winning party to like appeal the judgment?
Yeah, and you can't. So it would have to be that's not how courts work.
Right.
No,
You're
take a
talking
look
about
at
the
our
Fifth
win.
Circuit case versus the 11th or 4th Circuit cases?
Sorry, what was that?
Are you referring to the Fifth Circuit case or the 4th or 11th Circuit cases?
I don't know which one Will is.
Yeah.
Okay, but let me bring it back. Let me bring it back this way. Kostas, question for you on this too, because I know that this got a lot of people. NAGR is not the only one that got really, really worked up over this. I mean, I was a little pissy when I did my video. I'll admit it. Okay. I went back and I took a look at what was pled in the Reese case, and I took a look at what was ruled, and it was pled as a facial challenge. It was ruled as a successful facial challenge. If it's a successful facial challenge, it's still, I want you to explain to the viewers how it's still limited only to the named plaintiffs.
Well, it's not. So there's a lot of misconceptions about this. The government said itself in its brief that it is no longer enforcing the law as to anybody in the Fifth Circuit.
Right.
So this whole thing about staff members who were 18 to 25 years ago or whatever. No, we needed to go find middle school plaintiffs, I guess. That nonsense is about everywhere else. So if you're in one of the 3 states in the Fifth Circuit, as of now, the federal government is saying that they're not enforcing this handgun sales ban for 18 to 20-year-olds. But everywhere else, it would be limited to people who are members of staff as of 2020 when the lawsuit was filed. So again, that would be middle schoolers, at the time, who are now in that 18 to 20 bracket. That's what makes this all nonsensical. And then the judge went further than what the government asked. The government kind of hinted, sort of, I guess you could say, like, oh, they haven't turned over membership lists, so how do we know who to enforce this against? But they didn't actually ask for that. In fact, they conceded in their argument that they can't ask for that. And then the judge just kind of did it anyway, which is why I think they went back and retracted that and joined us properly in that motion. So it's been kind of a confusing mess. But what I've suggested on my Twitter and what I would urge the Trump administration to do is, right now we're caught in the crossfire of the Trump administration's war on universal injunctions. That's what this is about. It's not about the Second Amendment. It's that they hate universal injunctions because all these district judges across the country are making life hell for them.
Well, you heard Easterbrook brought up the Casa case during the Barnett arguments.
Yeah, exactly. So, and so what I suggest they do is when they lose, let's say they want to defend the law, fine, but they exhaust all appeals, they decide not to go to the Supreme Court, or they go to the Supreme Court and lose. I mean, at that point it would be national, but regardless, once they've lost, I would urge them to settle out of court with the parties and say, okay, plaintiffs, you don't need to file a class action lawsuit. You don't need to take further action because if you promise not to do that, we will cease enforcing this nationally. And that way, there's no national precedent that they can be cited against them on injunctions, but we still get what we want, which is we don't have to file 15 lawsuits in each, whatever it is, federal circuit.
Yeah, but we also then in that scenario, don't we end up in a situation where they just say, okay, we won't enforce it. And then all of a sudden you got a President Gavin Newsom or somebody like that. And it's like, well, we are going to enforce it.
Yeah, and we might have to cross that bridge eventually if a future president goes against the injunction. However, in that scenario, we still have a final circuit court judgment. And this isn't a scenario where the Supreme Court hasn't taken the case anyway, so at that point, if Newsom wants to resume enforcing it, there'll be a new lawsuit. Maybe the Ninth Circuit upholds the law, and then we've got a circuit split, and the Supreme Court can decide it.
Which would have been a much, much more acceptable strategy for the DOJ to take, rather than saying, well, we're caught between a rock and a hard place, and the plaintiffs are going to have to choose between their First Amendment rights and their Second Amendment.
And I think part of that problem is just, I think, to be fair to Pam Bondi, I think there's a lot of attorneys out there, and she's not going over these documents before each case. She's not up late going,
I know she's
we're
not.
going to have, so I think there's a lot of career attorneys just defaulting to defending federal laws. And that's why I think, it's reasonable to expect the government will generally defend the federal government's laws.
Now, see, that's actually where I might challenge that just a little bit, because that is actually one of the things that's also on our list. She needs to clean out the deep state attorneys that think that sort of thing is acceptable, right? That's why I voted for Trump. It was so he would clean the swamp. It was so he would drain the swamp. That is a part of it. So when you have these attorneys, these holdovers perhaps from previous administrations, they don't need to be in positions of responsibility guiding Second Amendment litigation or any litigation concerning a Bill of Rights guarantee, because then you do have the universal injunction is a problem. Obviously, that was a problem that the Supreme Court had to address. That was out of control. But this is something different. This is a Bill of Rights guarantee. That's kind of in a different class, and no strategy is acceptable that ends up with two classes of gun owners where your rights depend on what group you may be a member of. That's basically what the DOJ was arguing for, and that's the kind of thing that needs to be stopped. And if that means cleaning out the swamp within the DOJ, that's one of the things that needs to happen.
All right. I want to read a statement that I'm assuming I can read this since you put it out on Twitter 30 minutes before we went live today. This appears to be and you can correct me if I'm wrong, this would be, I believe, to be NAGR's official position as of 4:30 West Coast time today. Okay. One thing is apparent: Pam Bondi wants to be regarded as the most pro-gun attorney general ever. However, words and media interviews will never make it so. She must step up and do more, a lot more. Today, your National Association for Gun Rights is issuing a stern challenge to her. Prove it with policy action. And then you go through your thread, and during your thread, you do list some of the things that we got to talk about, some of the things we didn't have time to talk about. But as I'm scrolling through here, yeah, hey, good work, Hannah. You hit a couple of the top ones right away, so nice work. That is the position of NAGR today, October 13th.
Yes.
Okay.
We would love to be Pam Bondi's biggest fans. We would.
All right. I'm just the referee here, I say it all the time on the channel. I'm not a Bondi fanboy, but and I've only been doing this channel for a little over 4 years. So, I came in along during the Biden administration. Kostas has been in the trenches longer than me. But, you go back. I mean, you got the refunding of 925C. You got termination of Marvin Richardson and Megan Bennett. Doesn't appeal the range case. Actually begins granting relief through the Attorney General's office for restoration of rights. Settles the rare breed trigger case with you folks, with you guys. And agrees to give everybody their stuff back. Wow. Did not defend the pistol brace rule, allowing that thing to die, which I made hundreds of viewers off of that one. I appreciate that. Hired Andrew Bailey to come on in and then participates in oral arguments before the Seventh Circuit on behalf of lawful, responsible gun-owning Illinois residents. So I'm not saying, again, I'm not a fanboy, right? But I'm saying that there's a lot of things on her resume so far, 10 months into her term as Attorney General, that's firsts in the history of the United States Department of Justice.
No disagreement there. And those we unequivocally praise. We have praised them at the time, and we're thrilled to see them. That's why I use the term bipolar, right?
Yeah, well, yeah, no, it's a, and I used it in the video.
Right.
I did. They do. They've been a little schizophrenic, little bipolar in the way they deal with stuff. I totally agree. And listen, I said this in the video too. And Kostas, you may know this, judges, okay? The best quality a judge can have is be predictable. Even if you're just predictably shitty all the time, just be predictable, okay? And you want that from prosecutors too. As a criminal defense attorney, there's nothing worse than the schizophrenic prosecutor. One day is just like handing out plea deals like they're going out of style, and the next thing wants a death penalty on a misdemeanor. You just never know. So
I think what we're seeing, and others have noticed this as well, is the administration is much more likely to defend federal gun laws and much more likely to be critical of state gun laws. The problem is that state gun laws are the bigger problem. And as I like to joke and tease my red state friends, I like to say that red state gun owners don't have real problems. That's a dismissive joke. There are real problems, and that's not fair. But there's a kernel of truth to it, which is
there is, because you're only being attacked on one front.
Well, it's not only that; it's that like the level of for example, everyone got really mad that the NFA registration remains. I'm mad about it too. It shouldn't exist. It's unconstitutional. I would love to be able to register an NFA suppressor. I can't even have one because California bans them.
Bingo.
And now people are telling me about like 18 to 20-year-olds. Okay, yeah, I agree. SAF has all these cases, but like also California bans that anyway. So like there's all these things. So state gun laws are way worse than the federal issue. So when the administration has been historically strong on state level gun laws, that weighs, especially as a Californian, that weighs heavily to me. And then I see Hannah being like, fire Pam Bondi. I'm like, no, she's helping us. Why would you fire her?
No, and I get that. And that makes a lot of sense, that regional distinction.
Yeah.
The trouble is it leads to us wanting to grade on a curve, right? And you can't really do that. You have to compare her when you have an unequivocal policy set forward by the Trump administration right after he gets elected, saying basically, we are going to be unequivocally supporting the Second Amendment. His executive order was a directive to the DOJ, but also set the expectation to Americans. And when that's the case, you don't get to be graded on a curve. You don't get to be compared to previous administrations, which were nothing to write home about on gun control. You get to be compared to the Constitution. And that's kind of where we're coming.
That's fair. I think what they see it as is they do get to be graded on a curve, and they are historically strong. And I think, this whole DC thing, for example, is a great, they sped up DC permit issuance, but they are cracking down on people in DC without permits. And I think that encapsulates it well. They're pro Second Amendment to a point. And
right.
That point is historically better than anything we've seen in decades.
That is true.
And so that's, I think my expectations were just a lot lower than others. So they're blowing them out of the water, and I am grading them on the curve, but they have done historic things. And that's why I was taken aback and I was critical of Nagar's move to call for Pam Bondi to be fired, even though I'm a big fan of all your other work. And, that.
Hannah.
Yes.
Thank you so much for joining us today. You did pretty good under fire. You knew that last topic was going to be a little bit.
I did. I was wondering if you were going to swear me in before making me take a
before we let you go real quick, in case anyone wants to get involved with NAGR, NFGR, any of that, why don't you just put a quick plug in for what you guys got going over there?
Right. Well, our website's gunrights.org. We're basically, right now, we're fighting gun control fights in a number of states, and we're getting ready to go into primary season in those states too. For the people, for the lawmakers who have cast bad votes, there's going to be accountability coming for them. So if you want to get involved with that, join us at gunrights.org. You can follow me on Twitter, Hannah Hill _SC.
SC for South Carolina. She is a South Carolina. She's back home now in South Carolina. Congratulations. You do have a different glow about you now that you're back in the South. I know that Colorado wasn't really your style. So Hannah, thanks so much for being here. I really appreciate it.
Thank you both for having me. Yeah, I appreciate it so much.
Thanks so much. Bye-bye.
Yeah.
All right. Well, hey, that was an interesting conversation. We got two last little things we got to get through. But before we go there, listen, any other thoughts on this whole thing with Pam Bondi? And again, I'm not trying to single out NAGR because I think you and I know that there are other people, content creators included, that have been making the same cries. Anything you want to add on that?
I think, I get Hannah's point about not grading on a curve.
Yeah.
I think this is, I think I think it might've been Barack Obama who said it. I forget who it was, but they say politics is the art of the possible. I think you absolutely have to grade on a curve. You don't look a gift horse in the mouth. And when you have an administration that actually is doing historic things for the Second Amendment, you try and maximize that. That I'm not saying don't criticize them. I criticize them when they do stuff I don't like. But I think people are really failing to keep perspective here. A lot of gun tubers I respect, by the way. I watch their videos, and every other day, or GOA, it's not just Nagar, constantly just saying the administration's anti-gun, this and that. It's not true. I mean, they're not as pro-gun as we are, but they're certainly more pro-gun than any other administration in recent history, including, by the way, Trump term 1. The best thing we got one was just some good judges. I mean, other than that, it was very insignificant in terms of Second Amendment progress. So, we've got civil rights lawsuits, we've got amicus briefs. They're doing the largest rights restoration in history. take a step back and look at this big picture here, because I think overall it's a pretty good picture. And I say this, by the way, as someone who's really annoyed with how they're trying to narrow relief in
Right.
It's not
right.
that I
Well,
don't
we don't agree with every move they make, and there's some moves we've been very critical of. I know you. I follow you on Twitter. I've seen them. We've both been critical of them at times. We've been complimentary of at times. Here's my concern about this whole thing, and it has nothing to do with Attorney General Bondi, and it has everything to do with this 2A community of content creators. Is that for 4 years, everyone in this sphere was able to drive clicks through rage, fear, and uproar. Because the Biden administration was like the gift that just kept on giving when it came to that stuff, right? And then you had all these states going, crazy, like Illinois, like your state, like my state. Plus, you got it coming from the bottom up, from the top down. It's ridiculous. It's disingenuous. And so everybody was able to get clicks for 4 years straight. Everybody was able to raise money for 4 years straight on rage, right? Rage, fear, and all that. And I'm worried that maybe as a community, we don't know how to communicate any other way, that we became so ingrained into that as our messaging that we can't take a step back and go, yeah, it's not perfect, but God, it's a lot better than it used to be. And, is the glass half full or is the glass half empty? And I don't know. Everyone gets to come down on that, but we've got to learn to communicate. There will be plenty of things to be outraged about.
Yeah.
But we've got to be selective in communicating that. So when there is something we're being outraged about, we actually can do it.
I agree. And as someone who lives in California, let me tell you, it can be worse. It can be so much worse. So I think the glass right now is 2/3 full. It's not even half full. It's 2/3.
Well, there you go. And you know what? I actually tend to agree with that. All right, listen, last couple segments. The first one, I love this one. This is called To Live and Die in LA. By the way, a fantastic movie and one of the best car chases ever recorded. This is when they didn't have CGI, so they actually had to put real cars out there and smash them up and everything. Okay,
1980s LA is grimy and glorious in that movie.
Yeah, it is. This is our monthly check-in on how Kostas Moros is doing with his renewal on his concealed carry license.
I hope it's the only monthly check-in, Jesus.
Well, how long have we been in this process? Because
the California permits are valid for 2 years, so every 2 years you have to renew. This is my second renewal. The last one, which was 2 years ago, actually went pretty smoothly.
Yeah.
But this time, along with many, many other people, it's not just me, as much as I'd like to feel special and think they were just singling me out because they don't like me. So I applied in July, which was 80 days before the expiration. The earliest I could have applied is 90 days. They don't let you apply any earlier. I was only 10 days late because I was in Europe. But I got everything done early. I did my training before they told me to. So everything was paperwork.
So you have to do the training all over again too?
Yeah, it's an 8-hour course. First timers have to do 16 hours now. So I got to do an 8-hour course, requalify, all that. And so when they asked me for my training certificate, finally, I'd already done it. So I submitted that. Everything's been complete since mid-August. My permit expired September 27th. If I go check on the status on the website, it still says pending telephone appointment or whatever it is, because the appointment for renewals is telephonic. You don't actually have to go in. But they haven't called me.
That's convenient.
I emailed them a couple of times and said, hey, what's going on? And they basically said, first come, first serve, we'll get to you when we get to you. So now, like many others.
It expired last month.
Yeah, it's been expired since September 27th. And I've emailed them. I've checked the website. I've been waiting for a call. Nothing. So there's no legal way for me to carry in California right now.
It is illegal for you to carry in California right now.
Well, I would say that I still have a Second Amendment right to carry. So,
well, I agree with that completely.
Take that for
you
what
also live in the people's
LASC.
California, so you got all this other bullshit that you got to deal with down there. So, technically speaking, I'm not asking you what you're really doing, and I'm not asking. Technically speaking, pursuant to California law, it would be unlawful for you to carry a firearm outside your home right now.
Correct. I can't legally do it, and I can't apply anywhere else either because I'm a resident of LA County. I have to apply with LASC. They're the only game in town for me.
Yeah, well, they're getting really good. What was it, 3,900, and they got around to 2 of them. So that was around 2 applications.
Yeah, this is it's insane. And remember, there's no provision in California law, like I said earlier, where I automatically get to carry while my renewal's pending. There's nothing like that here. So once it expired, It's expired.
And here's what I want people to understand about California, because you guys are a no open carry state either, right?
Yeah, no open. Well, the law says that you can apply for an open carry permit if you live in a county with less than 200,000 people. But even in those counties with less than 200,000 people, no such permit has ever been issued to anybody.
Yeah. So since you can't open carry in the state, and now because your application apparently is caught in application purgatory at the current time, you literally cannot defend your life with a firearm outside of your home right now.
Well, I can. I just legally can't.
Legally speaking, everything's going to be in the league. Come on, you went to law school. You know,
if somebody wants to try and mug me and find out whether I'm in compliance with California law,
well,
let's find out.
I'm not wishing that on you at all.
It's getting late. It's getting late.
Last segment. It's called "What Are You Doing?" All right, and this is where you get to tell all of our viewers right now what's going on with the Second Amendment Foundation, because you guys got your hands in all sorts of cookie jars all around the country. And obviously, I don't expect the full rundown, but there's going to be some pretty cool, exciting projects. So why don't you tell everyone what you guys got rolling?
So for today, why don't we focus, because like I've said, I can't even keep track. We have so many lawsuits. But today there is one I can remember because we just filed it like an hour before this went live, which is...
Ooh, do tell.
Yeah. So last week, Governor Newsom signed the Glock ban bill. There was speculation, including on my part, that maybe he would veto it because it would make him look moderate. Nope, he defaulted to his true self and signed the Glock ban. So today, SAF, joined by FPC and the NRA, I hope I'm not forgetting anyone. If I am, apologies, but I think those are the three orgs, filed a lawsuit against, it's called James v. I think Bonta, challenging the Glock ban. So that's just filed about an hour before this show started. And this Glock ban bill will ban the sale of Glocks, the Shadow Systems guns, because those are Glock clones, and I think Duria, and then there's this one Smith & West model, the SDV40 or whatever.
Yeah, the SDV, right. Anything with a cruciform trigger bar.
Yeah, and a cruciform trigger bar, and then there's language in there about how if they modify the design to block the cruciform trigger bar, maybe they put a piece of metal there or something that not to block the cruciform, to block the Glock switches from being attached to it, then they can be re-added to the roster.
Right, we don't know. It has to be something that is not polymer.
Right. And that's another thing, because the newer Glocks are a little bit better about this, but we can't even get them in California because of the roster. So we have the Gen 3s. Glock, I know, has already stopped taking orders from dealers, so I don't know if they're planning some fix. They haven't told us. But for now, anyways, we're going to proceed with this lawsuit just in case these companies don't have a workaround for this, because these are the most common handguns in the country. And yet our governor, who claimed on a major podcast that he doesn't oppose the Second Amendment, went forward with the ban.
Yeah, he signed it, right? Well, and it's got an effective date of January 1st. So
yeah,
the other bills that he signed, Senate Bill 704 and Assembly Bill 1078, I think have like 2027 activation dates on them.
It's confusing on the Glock ban. That as I understand it, and I may have to double check this, dealers cannot receive new inventory after January 1st, but they don't actually have to see sales until July 1st, 2026. So you have a 6-month window. However, dealers have already said because Glock stopped taking orders, they're going to be out of their inventory before January 1st.
So right now, for any of our viewers who might be down in the state of California who've always thought about getting that Glock 19 or the Glock 43X, this would probably be the time to go do it down there, wouldn't it?
It might already be too late, but yeah, if you really are hurting for a Glock, go get one now, I guess. Yeah.
All right. Anything else you want to tell us about what the that was James v. Bonta? Can you ship me a copy of that complaint?
Yeah, it's posted on our Twitter, but yeah, I can go ahead and do that.
Yeah, just send it over. I'm gonna do a video on it because, California, you guys are the gift that keeps on giving down there. All right. Anything else we need to know about from Second Amendment
I think
Foundation?
I already mentioned we filed another NFA lawsuit last week. I think you covered it on your channel.
Yep.
And we filed the Santa Clara lawsuit a couple weeks back. So
that's the Jensen case, right? The Jensen case is your NFA suit.
The
interesting little argument on there. I like I like the whole Sunzinski getting undermined and all of that, but I like the extra little added bit you got about including Form 1s, and does that even affect interstate commerce? And this is outside their entire power. So it's a neat argument. I liked it. So.
Yeah.
All right. And then, hey, listen, for anyone who wants to get involved with Second Amendment Foundation, wants to show them some love, how can they give to the cause over there?
Yeah, sure. SAF.org. Go there. There's at the top of the webpage, you'll see become a member, donate, support staff, whatever that button says. And you can become a member or donate, and we'd love to have you. You can also, even if you can't donate, though, follow us on social media. I default to Twitter because that's where I live. It's /2AFDN on Twitter, but we're also on Instagram, on Facebook.
And how can they follow you on X? Because you are a warrior out there on X.
My handle is @MorosKostas, so my last name first, MorosKostas. I don't know why I did it that way, but that's what it is. So
yeah, well, I'm at Gun Washington, and that's because somebody had at Washington Gun, and they gave me the other one. All right, hey, this was fun, man. Did you have a good time doing this?
Yeah, it was a lot of fun.
Good. Well, you're always just sitting there behind your little keyboard, doing your little tweet thing, and I was like, no, we got to get you out here.
Next time I'll remember to turn on the lights in this room. Sorry, I just realized how dark my screen is.
That's okay. Yeah, we were losing you here. We only had a few more minutes before we were going to lose you to darkness altogether. Hey, listen, thanks a million, brother. This was fun. And for all you guys who tuned in, thanks a million. For you who are going to watch it on replay, thanks a million for watching that. Now, remember, we're going to be back again Monday, November 10th. It's always going to be the second Monday of the month. So we're going to be back on November 10th for Behind Enemy Lines Volume 2. And we're going to have Mark Smith of Four Boxes Diner joining. We're going to have a mega geek out session for that one.
That's going to be fun.
All right, brother. Till next time, thanks a million. And listen, we're gonna play. There's a little outro video, and then we'll stay online, and I'll stay online and deal with some of the comments. But eventually, it times out, and we're done. But if you guys got any other questions about anything we covered, our contact information is easy to find. You can always let us know. Everyone, thanks for tuning in. Appreciate it. Y'all stay safe. Thanks so much.